Thank you so much, Professor Johnson, for that gracious introduction, and thank the audience for that warm welcome. And I would also like to thank Dr. Martin Cook for inviting me once again to address an important military forum and for organizing such an impressive conference. I'm really honored to address this important audience and to share the podium with Mike Schmitt, who is one of the foremost experts on the law of armed conflict. As Martin knows, whenever I have the privilege of addressing a military audience, I use the opportunity to convey my deep gratitude to the United States Armed Services for the critically important role that you have played in my life. I know I speak for countless Americans who could tell similar stories, so I'll just briefly share mine as an example. My father was born in Germany in 1922 as what Nazis called a Jew of the second degree. That was the term that they used for somebody who had one parent who was Jewish. For that crime, when he was a teenager, he was imprisoned and almost died in the forced labor camp at Buchenwald. But he was liberated by the American Armed Forces and came to this country as a refugee after the war. So for the rest of his life, my dad continued to feel and to convey to me his undying gratitude to the U.S. military personnel who gave him his freedom in the most literal sense. Moreover, to get very personal, the U.S. military freed my father just one day before he had been scheduled to submit to the Nazis' plan of forced sterilization. So I literally owe my life to the military. And I know that all of you commit your lives literally to protect the rest of us, which really leaves me awestruck. I am extremely dedicated to civil liberties and human rights, but I certainly have never deliberately put my life on the line for them. I've received death threats, but that was not deliberate, so I truly am in awe of all of you. Another source of my deep respect for the military is the other most important man in my life, my husband, who served in the Israeli Air Force and fought in the 1967 and 1973 wars in Israel. And I happen to think that we can learn a lot from Israel about countering terrorism while respecting human rights, including on today's topic of targeted killing, as I'll explain shortly. As a human rights activist, I've always felt a close bond with all of you because we have all dedicated our lives to defending the United States, not just as a place on the map, but more important as a system of government and the principles it reflects. And of course, this is so bound up with the whole topic of ethics that you've been focusing on during this conference. Each of you pledges that you will support and defend the Constitution of the United States against all enemies, foreign and domestic. And that's also the core mission, using other means of struggle, but it's also the core mission of the American Civil Liberties Union. We do our best to defend all fundamental freedoms for everyone in this country, no matter who they are, no matter what they believe, even if their beliefs are inconsistent with our own civil libertarian values. And in that same neutral spirit, we seek to protect these same values whenever they are threatened by any government official, no matter who and no matter what party or ideology. Today's topic really well illustrates this. Both post-9/11 presidents have, in our view, unjustifiably sacrificed civil liberties in the name of the so-called war on terror, and in fact, targeted killings have been especially problematic under the Obama administration, which has dramatically increased them. Interestingly and somewhat distressingly, some strong critics of President Bush's detention of terror suspects have not been equally critical of President Obama's killing of such suspects. But the ACLU, never fear, has been an equal opportunity critic of both presidents and both policies, which makes us extremely neutral in our critiques, considering that the CIA has played a leading role in targeted killings. And as some of you may recall, while she was a presidential candidate, Michelle Bachmann asserted that under the Obama administration, the ACLU is actually running the CIA. It was as much a surprise to us as it was to the CIA. And that claim, which she repeated, prompted the ACLU to issue a statement about what we would do if we did run the CIA, starting with that we would stop suing ourselves. Seriously, we use that opportunity to explain why the CIA's involvement in the targeted killing program is especially troubling given the CIA's secrecy. In fact, many experts, including national security experts, have urged that this program should be limited to the military, given the military's greater transparency and accountability. And given that the topic is ethics, I really want to mention just one more important connection between the ACLU and the U.S. Navy in particular. In 2005, I had the honor of presenting the ACLU's highest award, which we give only every 2 years. It's a very big deal. It comes with a lot of money, a lot of publicity. And I had the honor as president then of presenting it to 2 officers of the United States Navy, namely Lieutenant Commanders Philip Sundell and Charles Swift. They received that award along with 3 other active officers in the U.S. Air Force, Army, and Marine Corps. All of them were military lawyers who were appointed to represent accused enemy combatants being held at Guantanamo, and who really courageously advocated their clients' rights. The ceremony at which these officers received the award and addressed the assembled ACLU leaders truly was one of the most moving events I've ever attended. Likewise, they told us that they felt the same way, and I'd just like to share a few words from the thank you note that Charlie Swift sent me afterwards. He said, "To receive such praise from an organization like the ACLU, with all of its members dedicated to the fight for civil rights, was truly an honor. The comments and well wishes we received from so many of the attendees were an inspiration. We were particularly pleased to hear many ACLU activists who are former servicemen and women tell us how this greatly renewed their pride in our armed services." Well, Martin asked me to present the ACLU's perspective on the targeted killing issue as reflected in 2 interrelated initiatives that we've taken. First, starting more than 2 years ago, we've been filing a series of requests under the Freedom of Information Act, the FOIA, the FOIA, for information about the government's legal and factual bases for its targeted killing program. Second, in August 2010, we filed a lawsuit on behalf of the father of Anwar al-Awlaki, whom Professor Johnson described. Our lawsuit sought to constrain the government's targeted killing program specifically as applied to the particular factual context of the al-Awlaki case, as well as others, namely targeting U.S. citizens who are far from any field of armed conflict. Of course, that's only a subset of the situations in which the government has been implementing its dramatically expanded targeted killing program under the Obama administration, and the program raises many challenging issues in all other factual contexts too. I assume that Mike will address some of the other contexts, but the situation on which the ACLU focused raises the most pointed legal and ethical issues. And here I'd like to quote Jamil Jaffer, who's the ACLU's deputy legal director. He said, "As the al-Awlaki case demonstrates, American citizens far from any battlefield can be executed by their own government without judicial process and on the basis of standards and evidence that are kept secret, not just from the public, but from the courts. If the Constitution means anything, it surely means that the president does not have unreviewable authority to summarily execute any American whom he deems to present a threat." Now, you may have noticed that I was referring to our lawsuit in the past tense, That is because in December of 2010, the lower court dismissed this case on so-called justiciability grounds without addressing the merits of the claims. Specifically, Judge John Bates of the Federal Trial Court in Washington, D.C., ruled that the targeted killing program is completely consigned to executive discretion, completely immune from any judicial review. Thus, as Jamil Jaffer said, the president has unilaterally deprived United States citizens of the most fundamental right of all, the right to life, based on legal standards and factual evidence that the courts do not even see, let alone review. How can that possibly be? In our cherished system of checks and balances, the rule of law, government accountability to we the people, who are the governors, right? We elect those others to represent us. Now, even Judge Bates himself posed this very question about the government's sweeping claims for secrecy and unchecked power. At the very beginning of his opinion, here's what he wrote. How is it that judicial approval is required when the United States decides to target a U.S. citizen overseas for electronic surveillance, but that, according to the government, judicial scrutiny is prohibited when the United States decides to target a U.S. citizen overseas for death? Can the executive order the assassination of a U.S. citizen without first affording him any judicial process whatsoever, based on the mere assertion that he is a dangerous member of a terrorist organization? The only other national court to consider the targeted killing of a suspected terrorist, the Israeli Supreme Court, held that the targeting decision must be subject to judicial review, even when the targeted individuals are not Israeli citizens, and even when they are targeted in an ongoing armed conflict. In other words, when the facts would support more military discretion and power. Now, to be sure, the Israeli High Court deferred to military commanders' discretion in determining whether and when to target a particular suspect, but the court laid out the general legal framework within which the commanders had to exercise their discretion. There's a big difference between such judicial deference to military expertise, which is appropriate, versus judicial abdication, which is not appropriate. I should note that this important Israeli Supreme Court opinion repeatedly cites and relies on a book chapter that Mike wrote 7 times. Mike, I bet you didn't even count them up. It's really a wonderful tribute to his very important work, and of course a strong signal that the court's ruling was correct, right? Now, I'd like to quote just one passage from that opinion, which was written by the court's respected former president, which is the equivalent of our Chief Justice, Ron Barak, who teaches at Yale Law School, among many other places. He said, "The court does not replace the discretion of the military commander regarding the military considerations. That is his expertise. Rather, we examine the result from the standpoint of law. That is our expertise." And that is the very same stance, the very same dichotomy that the U.S. Supreme Court has struck in a series of post-9/11 rulings. It rejected the government's claims that there should be no judicial review at all, and that the challenged policies should reside wholly within executive and military discretion. The court memorably made this point in what I think is the single most quoted line in all of its post-9/11 cases. It comes from Justice O'Connor's opinion in the Hamdi case in 2004, as she famously declared, "A state of war is not a blank check for the president when it comes to the rights of the nation's citizens. Whatever power the United States Constitution envisions for the executive in its exchanges with other nations or with enemy organizations in times of conflict, it most assuredly envisions a role for all 3 branches when individual liberties are at stake." So, although Judge Bates in the trial court in the Iraqi case accepted the government's non-justiciability arguments, I'm hopeful that ultimately a U.S. court will issue the kind of broad legal guidelines to constrain the targeted killing power that the Israeli Supreme Court issued. I'd like to briefly summarize those rulings by the Israeli High Court. First, it held that the government has a heavy burden of proof to thoroughly and carefully verify the suspect's identity and terrorist activity. Secondly, the government may not use lethal force if the suspect can feasibly be arrested, interrogated, and put on trial. Rather, targeted killing can be used only when these alternative means would involve a great risk to the lives of security forces and others. And third, after any targeted killing, executive authorities have to conduct an independent review of its legality, which is conducted by individuals who weren't involved in the killing, which should be as public as secured national security permits. And finally, the independent executive branch review should in turn be subject to limited judicial review after the fact to be sure that it was fair and reasonable. I would like to stress that key aspects of this approach, which the Israeli Supreme Court outlined, are consistent both with the actual practice of the Israeli military prior to the court's decision and also consistent with the relief that the ACLU was seeking in the Alaki case. So on that first point, I'd like to quote the Israeli government's brief, which described the restraints it imposed on its own before the court ruling. Quote, "Targeted killings are performed only as an exceptional step when there is no alternative. In every case, an attempt is made to minimize the collateral damage liable to be caused to civilians." And there's also significant overlap with the ACLU's position. In contrast to the plaintiff organizations in the Israeli case, which asked the court to rule that all targeted killings are automatically unconstitutional, that's not what the ACLU argued. We instead sought essentially what the Israeli court granted, namely a statement of general legal parameters for constraining military discretion in making particular targeting decisions and retrospective judicial review of any such decision to ensure that it was within those parameters. Notably, this means that no court would be intervening in real-time decision-making about any specific use of lethal force. Before I say more about those substantive guidelines that we advocated in the Alaki case, I first want to note the important procedural claim that we also made in that case, which overlaps with our FOIA requests. And in both of these proceedings, we are seeking information about what standards, what procedures the government is using. Our lawsuit focused on the government's duty to disclose such information to Alaki and any other citizen it targets. And our FOIA efforts focus on this duty that runs to we the people, again, to quote our Constitution's opening words. First, for anyone that the government is targeting for killing, the disclosure claim is rooted in the Due Process Clause of the Fifth Amendment, which provides that government may not deprive any person of life, liberty, or property without due process of law. And as the Supreme Court has held, this means that before government may threaten even our property or our liberty, let alone our very lives, at a bare minimum, it must at least give us notice of its claimed basis for doing this. Specifically, what are the legal standards that we assertively have violated? And second, what is the factual evidence that allegedly demonstrates that violation? Moreover, the court has held that the government must also give us an opportunity to respond to the government's legal and factual claims. These core bedrock elements of procedural due process were what the Supreme Court held that our government had to honor for the so-called enemy combatants that it captured on battlefields in Afghanistan and imprisoned in a couple major post-9/11 cases. So surely, if the government must honor these core due process guarantees before depriving enemy combatants of liberty, then certainly it must do so before depriving an American citizen of life itself, especially when that citizen is killed far from any battlefield. Disclosing the standards for summarily executing a U.S. citizen is also essential for the accountability and transparency that undergird our representative democracy. On this disclosure issue, the ACLU has had strong support from across the political spectrum and also from military and intelligence experts, and notably its proponents of the targeted killing program who strongly support disclosure precisely to bolster its legitimacy. For example, John Bellinger, who was legal counsel for both the National Security Council and the State Department under President George W. Bush, said, if we don't explain our legal rationales and the limits we apply now, then we'll lose international support and open the door to other countries to use targeted killing where we consider it unjustified. Now, right after the Alaki killing, the media began reporting about a legal memorandum that was written by the Justice Department's Office of Legal Counsel, or OLC, that set out the claimed legal justification for that killing. These reports triggered an outpouring of calls on the administration to release a redacted, classified version of the memo, just as there was, you'll recall, concerning the Bush OLC's legal memos authorizing torture. For example, Jack Goldsmith, who ran the OLC under President Bush, stressed that public scrutiny is especially appropriate since, as Judge Bates' ruling shows, courts are unlikely to review the targeted killing program. Therefore, legal accountability for targeted killings depends on a thorough public legal explanation by the administration. Although the government continues to stonewall official disclosures about the targeted killing program, many key officials have selectively leaked factual claims about it. So we're in the worst of both worlds. On the one hand, the government trumpets conclusory claims about the asserted positive impact of the program. On the other hand, the government stifles access to specific information which would permit the public and press, not to mention Congress, which is also being denied this information. We're all being denied the ability to analyze the government's claims. Speaking of leaks, a couple of weeks ago, we learned from leaks that all of the pressure to disclose more information about the targeted killing program has apparently had some impact. It's reportedly led to big debates within the Obama administration, and the apparent upshot is that we are going to get some more information from Attorney General Eric Holder in a speech that he will be delivering soon, although no date has yet been given. Now I'd like to make a couple more comments about the key substantive issues that we raised in the Alaki lawsuit, namely when the government should be allowed to kill a U.S. citizen who is far from the battlefield on the ground that he is a suspected terrorist. We argued that under U.S. and international law, such lethal force should be confined to situations where the suspect poses an imminent danger to life or limb, and there is no feasible alternative for averting that danger. And before I explain the U.S. authorities for that standard, I just want to make one observation about the pertinent international law standards. Here, I have absolutely nothing approaching Mike's vast expertise, but I always see the silver lining to the cloud, and as I told Mike over lunch, as I was plowing through his learned writings and that of many other experts who specialize on that particular area, I think with my lack of precise knowledge, specific knowledge, it was a little bit easier for me to see some of the broad underlying themes, to see more of the forest than the trees. And what really struck me from that perspective was that even though various bodies of international law and various doctrines certainly have a lot of differences and details and terminology, that they were all linked together by very important, fundamental, key common concepts, which are also linked to core concepts of U.S. constitutional law and civil liberties principles. And when you think about it, these links really make sense because the core concepts embody basic ethical concerns and and basic pragmatic concerns. For example, all of you are familiar with the prerequisites for using lethal force even in armed conflict, when of course there are the fewest constraints on such force, but even in that situation, lethal force must only be used consistent with principles that are often labeled distinction or discrimination, precaution, proportionality, and necessity. And in a nutshell, I'm used to doing media interviews, as Professor Johnson's kind introduction mentioned, so I'm used to kind of boiling things down to a soundbite. And if I reduced all of that to a soundbite, I would say they essentially demand that any use of lethal force must maximize military gain and minimize civilian loss. I mean, certainly that should be the bottom line standard in terms of both ethics and practicality. It fosters not only the fundamental right to life, but also national security concerns. Security experts concur that whenever feasible, we should capture a suspect rather than kill him because of the potential intelligence value of interrogating him. Now, as I noted earlier, these concepts were embodied in the standards that the Israeli military followed even before the court ruling on point. To be sure, the devil is in the details, as the saying goes, and reasonable people certainly disagree, and I know from Mike that the more expertise there is, probably the more ferocious the disagreements are about what the details are and whether the principles are satisfied in any particular case. But I still think it's important for us to have this perspective that disagreements are more over matters of judgment, degree, and factual application, and more so than disagreement over fundamental values and standards. The governing U.S. constitutional principles also can be boiled down at bottom in essentially the same way to a cost-benefit balancing, weighing a targeted killing's costs to life, liberty, and security on the one hand against its benefits to those very same interests. And I'd like to underscore here that all of the values at issue, life, liberty, and security, all of these are implicated on both sides of the balance, contrary to a lot of oversimplified scapegoating type political rhetoric that we hear on point. A targeted killing can undermine security by eliminating potential intelligence, reducing allied support, and fueling terrorist recruiting. Likewise, of course, targeted killing can cause a net savings to liberty and life, in particular for security forces and civilians. So this type of flexible balancing approach was endorsed by the U.S. Supreme Court in its two most pertinent post-9/11 cases, specifically concerning the government's power to detain suspected terrorists. The court ruled that the procedures and standards would turn on all the specific facts and circumstances in each situation. It rejected any bright-line, formalistic approach based on factors such as citizenship or sovereignty. So in the 2008 Boumediene case, the court held that the government had to provide basic due process to justify continued detention even for aliens who had been captured on a foreign battlefield and were being detained in Guantanamo beyond sovereign U.S. territory. In both that case and the Hamdi case, which involved U.S. citizens, the court used a functional, flexible approach, weighing the costs and benefits from both the detainee and government perspectives. And while the court ruled that even non-citizens should have some constitutional protection, it indicated that citizens should have heightened protection. Moreover, outside the context of armed conflict, the court repeatedly has held that government may threaten a suspect's life only in the extraordinary circumstances when necessary to avert an imminent harm to life, an imminent threat to life, or physical safety. It's repeatedly reaffirmed this fundamental protection for the core right to life under both the Due Process Clause of the Fifth Amendment, which I've already mentioned, and also the Fourth Amendment, which limits the government's power to seize us. I'm mindful of the clock, so I won't say any more about the constitutional doctrine here, but just to explain why it's so important, given our human fallibility, lack of perfection, at least speaking for me, absent some due process, indeed even with due process, there is an inevitable danger that the government will kill an innocent person or kill someone who does not pose an imminent danger. And that risk is especially high where targeting decisions are based on intelligence rather than evidence that is admissible in court. Just consider the erroneous judgments our government has already made about accused terrorists since 9/11. Officials declared that they had imprisoned in Guantanamo only the worst of the worst, yet the government itself has voluntarily released or cleared for release 223 such inmates out of a total of 625. That's more than 35%. Moreover, for most Gitmo inmates whose habeas petitions the courts have considered, the government hasn't even been able to satisfy its relatively light evidentiary burden, which is to show by a preponderance of the evidence that the individual was part of or substantially supported al-Qaeda, the Taliban, or affiliated groups. Of the 57 Gitmo habeas cases the courts have decided, the government has lost a full 37, which is almost 65%. So how can we let the government rely on the same kinds of intelligence information that doesn't even justify detention to justify summary execution without any due process at all? Killing the wrong person is, of course, catastrophic from a human rights perspective, but it's hardly better from a national security perspective. At best, killing someone who doesn't actually pose a sufficient terrorist threat doesn't advance national security. At worst, it undermines national security by depriving us of intelligence, increasing terrorist recruitment, and decreasing allied and public support. So thank you very much for giving me an opportunity to engage with you on these important issues, and thank you again for your wonderful service to our liberty and our lives, as well as our security.
Well, I think I'll stay here. Let me thank Martin as well for inviting us here, although I find the choice of two lawyers to close an ethics conference rather curious, but as a lawyer, I think it's a great idea, and this should set a precedent in the future. Martin has asked me to speak about targeted killings in international law, and I think it's very important that when we talk about targeted killings that we understand that there's a distinction between domestic legal standards, which Nadine has talked about, and international legal standards, which I've talked about, or which I will talk about. And the classic case is the Israeli Supreme Court opinion of 2006, the famous targeted killing case, because much of that decision was driven not by international legal standards that would be relevant to us as a matter of law, but rather by domestic Israeli legal standards. So when we talk about the various points that Nadine made, the requirement to identify the target, that's international law. That's clear. That binds you as much as it binds an Israeli. But the decision on whether to capture versus kill is an Israeli legal standard, not an international law standard. So whether or not that's a good idea, I don't know. Whether or not that's ethical, I don't know. I'm a lawyer, I don't do ethics. But that is an issue of domestic law, and that's what you must understand. So what I'm going to do today is walk through, by the numbers, the legal standards that apply as a matter of international law to you and applied to the Canadians, because I see General Watkin in the audience, that apply to every state in the world. Now, when we're doing this, what we need to understand is that this is an area of law. Let me make sure this works. This is an area of law that has been in great flux. Certainly that's true with regard to my lifetime. I'm slightly older, although not much, than you are. In 1991, the United States Air Force tried to kill Saddam Hussein. The Chief of Staff of the Air Force came out and said, well, we were trying to decapitate the Iraqi regime during Operation Desert Storm. And as a result of that, he was fired. And American officials came out and denied what was obvious to anyone who was watching. But remember, by 2003, military operations and Operation Iraqi Freedom were actually advanced when an opportunity to take out Saddam Hussein surfaced. We launched those operations earlier than planned because the possibility of killing him surfaced. And as the operation went on, as Operation Iraqi Freedom went on, we conducted over 50 targeted killing, decapitation type strikes, none of which were successful. But nevertheless, in the review of those operations, Human Rights Watch came out and objected not to the fact that the operations were occurring, but rather to how they were being conducted. They had concerns over the reliability of intelligence. So this is a major change. Firing the Chief of Staff to Human Rights Watch, basically saying, we understand that you have the right to conduct such operations, but be careful when you do so, ensure that you comply with the applicable law of armed conflict. And then just in December of this year, Human Rights Watch sent a letter to President Obama about drone attacks, in which they specifically said that you can engage in lethal operations during armed conflict, during a war, on the battlefield, and not only there, but in situations of law enforcement, when you're outside the paradigm of armed conflict, although, of course, because you are in a law enforcement paradigm, different standards apply. For example, it must be the last resort, and so forth. So we've come a long ways in a very short time with regard to this body of law. So let me show you what the law is today. International law, because this is very different than what Nadine talked about. She's talking about the Fifth Amendment. I happen to agree with her in many of the things she said. For example, I think the United States government should come out and say what their legal standard is. If we're going to kill people, we ought to be able to at least articulate the legal basis on which those operations are being conducted. So I don't disagree on things like that. But let me talk about the international law standard. The first question you have is, when can we conduct a targeted killing operation? Well, the United States has made clear, a little late, I will tell you, but made clear by now that the legal basis for most operations is Article 51 of the United Nations Charter, which sets forth the right to self-defense. Harold Koh, who is the State Department's legal advisor, made a very famous speech on this at the American Society of International Law meeting. This is Article 51 here. It's very simple. If you are the victim of an armed attack, then you may resort to force to defend yourself. And not only that, if you are the victim of an armed attack, then you may get help from other people who themselves were not the victim of that armed attack. We talk a lot about Iran and Israel. Do we have the right to attack Iran now? In my mind, absolutely not. Absolutely unlawful. But Israel, that's a slightly different case. And if Israel had the right to defend itself anticipatorily against Iran, then the United States would have the right to go to the assistance of Israel if Israel requested our assistance. So note the collective piece. Also, you should know that this is somewhat controversial because for many years, certainly what I learned in law school, this provision was deemed only to apply to attacks from states. If the attack came from a terrorist group, that was law enforcement. In other words, the response was not military. The response was through cooperative law enforcement. But that changed, and that changed dramatically on a single day. And that day was, of course, 9/11. Because as soon as the United States was attacked on 9/11, virtually the entire international community said, this is a situation where the right to use force in self-defense pursuant to Article 51 of the Charter applies. And the international community said that at a time where no one suspected that any state might be behind the attack. So by the 12th, it was becoming clear that the international community now accepted a new norm. A norm which says that if your state is the victim of an attack by a non-state actor, by a terrorist group, you may respond forcefully pursuant to your right of self-defense, and others may come to your assistance. We know this because the Security Council in the first 2 weeks passed resolutions saying as much, and then subsequently passed lots of other resolutions. NATO invoked Article 5, the collective defense provision of the North Atlantic Treaty. The UAS did the same. ANZUS did the same. States offered us bilateral assistance. 48 different states in the first 2 weeks offered the United States assistance that ranged from of troops on the ground to overflight rights, use our airfields. And even folks that aren't such good friends, like the Russians and the Chinese and some Arab states, offered us assistance in the aftermath of 9/11. So it was crystal clear at that point that the law, the understanding of the law had changed, and had changed rather rapidly. We can now use military force against non-state actors. However, then the lawyers became involved. It's not always a good thing. The lawyers became involved. The International Court of Justice issued not one, but 2 opinions. One had to do with the wall that the Israelis built. It's actually a fence, but they call it the wall case. And the other had to do with incursions by Uganda into the Congo, chasing guerrillas into the Congo and engaging them in the Congo. And in both of those cases, the International Court of Justice came out and said, you know, the law of self-defense will not apply unless the actor is a state or unless a state is behind the operation. But if it's just a non-state actor, well, then the law of self-defense doesn't apply. Don't call the United States Marine Corps or the Air Force or the Navy or the Army. You need to call the FBI. Okay? It's law enforcement. This opinion, these judgments, rather, they were met with enormous criticism. I'm one of the people that think they got it wrong, but not only criticism from folks outside the court, there were very strong dissents from some of the power judges on the court. The British judge, Ross Higgins, the American judge, the Dutch judge, the German judge. Most of the classic law of war, law of conflict people on the court said, you got it wrong. You haven't been paying attention. You haven't watched Al Jazeera, CNN, and BBC because you act as if we are a decade earlier than we are. So this is very controversial. I believe today, clearly the law is, and states understand it to be, that you may use self-defense against the acts of non-state actors like terrorists. Well, if that's the law, then the question is, when can you use self-defense against these non-state actors? This is relatively settled law. There are 3 requirements. The first requirement is necessity. Necessity is pretty easy. It says you're using force because other things won't work. Law enforcement standing alone won't work to defend yourself. Diplomatic activity won't work to effectively defend your state. Economic sanctions won't work to effectively defend the state. And you have to therefore resort to military force. That's the first requirement. The second requirement is that if you act in self-defense, you comport with the principle of proportionality, which is not the sort of proportionality you think of as war fighters, has nothing to do with civilian casualties. It says, the proportionality in this context says, don't do more than necessary to defend yourself. So if it's small border skirmish, you don't need to invade the country and conquer the capital. And then the third requirement is immediacy. It's a temporal requirement. It says, listen, don't act too soon, don't act too late. We understand that you may have to act in anticipation of an attack because you don't have to take the first shot, but not too early. And oh, by the way, this is about defending yourself, not punishing the other state. So don't act too late. Don't suffer a blow and 5 months later say, okay, now we're acting in self-defense, that's why we bombed you. So there has to be some temporal proximity to the armed attack which is going to occur. Now, some caveats that are important in the counterterrorism context. The first is that you don't have to wait till the attack comes. You may act in anticipation of the attack, and the action in anticipation of the attack may be well before the attack comes. You're hearing a lot about this right now in the press. It has to do with the Israelis. Can they act now because it may be too late if they delay? Well, the law recognizes, at least in my view, that you can act in anticipation. The standard I apply is the last window of opportunity standard. In other words, surely the law cannot be that your right to act anticipatorily matures after it's too late, when it won't do any good. So you have to wait until, if you don't act now, it's going to be too late. Your window of opportunity to effectively defend yourself may close. And if we're talking about terrorists, that may be a long, long time before they act. Because their modus operandi is not to have you know they're coming. They don't line up on the border, they don't mobilize forces and so forth. Second caveat, there is a temporal requirement, but after the first blow, that temporal requirement goes away. In other words, you don't go, if you're fighting a group like Al-Qaeda, you don't go through the analysis over and over and over again. Once they strike, then the campaign has begun, and anything you do there is part of that campaign. There is no longer a requirement to go through the analysis again. And then the third thing I wanted to mention, because it's very, very important, very topical because of activities in Yemen, but most significantly Pakistan, is when can you act in another state? Not another state which is behind the operation. Clearly you can act there. But when can you act when the bad guys are in a state that isn't behind the operation? There's a problem here. That state has a right under international law to territorial integrity. It's their country. You don't have a right to go in there unless they consent. On the other hand, you have a right to self-defense. So international law requires a balancing of these two rights, seeks to find an accommodation of the rights that best meets both. What's that accommodation? Well, in my view, certainly the view of the United States, it works like this. You have to tell the other state, listen, you have a legal obligation to ensure your territory is not used to the detriment of other countries like us. So police your territory. And you have to give them a reasonable opportunity to do so. But in the event that they cannot, maybe they don't have the assets, maybe the bad guys are too remote. If they cannot, or they do not, maybe they're in bed with the bad guys. Maybe they're sympathetic to the bad guys. If they cannot or do not, then you have the right to cross into that territory to conduct kinetic operations, but only to the extent necessary to effectuate your right to self-defense. So it's not the gloves come off if they harbor terrorists. It's you can then penetrate their country despite the right of territorial integrity to conduct your operation to effectively defend yourself. Now, there is a separate legal basis that people often forget for crossing a border, and that's if you're in an armed conflict. An armed conflict, by the way, is a legal term of art. It means something in law. There are two types. The first legal type of armed conflict is an international armed conflict. It's state on state. State fights state. In such a case, the law is clear. It's been clear for a century. If you're in a fight with another state, you can conduct operations in their country, in your country. You can conduct operations in the global commons, at sea, on the high sea, beyond the territorial sea, international airspace. And you can conduct operations in neutral territory in the event they don't comply with their duty under the law of neutrality to make sure belligerents aren't there doing stuff. More complicated is the other form of armed conflict, and that's non-international armed conflict. It's, again, a legal term. If it's non-international armed conflict, it's a state against an organized armed group, like a terrorist group, an insurgent group, or two of these groups against each other. If this is the case, there is no clear law, there is no express law in this area, but I believe most scholars, practitioners, and states come to the conclusion that the same sort of rule applies. The other state, the state in which the bad guys have crossed back into, that state has an obligation to police its territory. If it does not, you can go in there to put an end to their activities, but only to put an end to their activities. Now, second question. Second question is what law applies? Because we need to be careful. I've made the distinction between domestic and international law. But within international law, there are different categories of law. And what law applies depends on the type of conflict you're in. And those bodies of law are different. So the first thing is the international armed conflict. It's the easiest. It's state on state. State A versus state B, state on state fight. What applies? Everything. Pretty much everything applies. Lots and lots and lots of treaties, not only treaties, but what we call customary international law. It's law that kind of derives from the practice of states and matures into unwritten law. It applies. Now, the second form of armed conflict is non-international armed conflict, as I mentioned, state on non-state actor. There, it's not any fight with a group like this. It has to be a pretty severe fight, because there may be riots that a non-state group is involved in. Individuals may do dramatic things, but they're not groups. So the 4 requirements for this body of law to apply in an internal conflict are: it has to be a group, doesn't apply to individuals. That group has to be pretty well organized, an interesting question in the cyber context. The fighting has to be relatively intense, so one-off pinpricks don't work. And it has to be protracted. In other words, it has to occur over time. If this is the case, a much smaller body of law applies, called the law of non-international armed conflict. But for our purposes today, that doesn't matter, because the rules regarding targeting for international and non-international armed conflict, which I'll talk about in just a second, are almost identical. Where the difference comes is if for some reason you don't have an armed conflict. And that's the case of a law enforcement regime. For example, remember the individual. It's not a group, but it's an individual, so it can't be an armed conflict. It's a group, but the fighting isn't intense enough. Okay. It's a group, but they're not organized enough. In these cases, you're talking about law enforcement. And if you're talking about law enforcement, then all the rules that you've learned in the law of armed conflict are completely inapplicable. Human rights law applies, domestic law applies, and there the distinctions are dramatic. Because in an armed conflict, you may shoot someone because of who they are, because it's called status-based engagement, because they are a member of the enemy, because they are a member of an organized armed group. Whereas in the human rights environment, you can't do that. You can only shoot someone based upon what they are doing. Moreover, we heard a mention of the capture versus kill rule. In my view, capture versus kill doesn't apply. It should apply as a matter of operational good sense, but as a matter of law, there's no requirement to capture, not kill, if you're in an armed conflict. None whatsoever. However, in the human rights regime, absolutely that is the rule. So you need to know what type of fight you're in before you know the rules of the game. It's all rather complex. And it's particularly complex in the case of transnational terrorism. Because here we don't have an ongoing conflict. And really what we have is 3 views that have emerged. The first view, and it is by far the least adhered to view, the minority view by a lot, is that, listen, if you're talking transnational terrorists, they're criminals, just criminals. So the human rights law, that's what applies, not the law of armed conflict. That's very much a minority view. The second view, adopted by our Supreme Court in a case that Nadine mentioned, Hamdan, which I happen to agree with, which the International Committee of the Red Cross tends to agree with, is that these conflicts are non-international because we're fighting a non-state actor. We don't have state on state. And then the third view is that it's international. This is the Israeli Supreme Court opinion. And they would say it's international because it crosses borders. Once it crosses borders, it's international. For our purpose, this is very important stuff for detention. But for our purpose today, in terms of targeting, the second 2 are kind of sort of the same. So what we really need to worry about is the distinction between something that happens in an armed conflict and stuff that you're doing that isn't tied to armed conflict. Now, third question, who can you attack? Well, if we're talking about human rights law, this is relatively simple, because you may only use lethal force against an individual. Remember I said acting, an individual who's posing an imminent threat of death or serious injury to you or to someone else. It's not status-based, it's action-based. And even then, you may only do that if less extreme measures are not available. And occasionally we Americans expand it to critical infrastructure. Most other countries don't. Most other countries, and certainly we would accept this as well, you have to be posing a threat to him that he's going to be killed or suffer grievous bodily injury. Otherwise, you cannot pull the trigger. This is very important in the terrorism context. Now, Domestic law varies from state to state. If we move to armed conflict, which in my view, virtually all of the targeting killing operations we're doing fall in the context of armed conflict, there you should know the rules of the game, at least the broad rules. The principle of distinction, also mentioned by Nadine, applies. It's pretty simple. You have to distinguish between combatants, that's you, and civilians, that's us. Okay? And you must distinguish between military objectives and civilian objects, not horribly important in the targeted killing context. You, of course, may attack enemy combatants who are lawful combatants. That means they comply with certain criteria, like they wear uniforms or other distinguishing emblems, markings, they carry their arms openly, and so forth. You may attack enemy regular armed forces and reserves, militia, and so forth. That's not a problem. The problem is that you don't face those folks very often. Today, you're typically facing a group that doesn't meet those criteria. They don't, for example, generally comply with LOAC. They don't wear uniforms. They're terrorist groups or insurgent groups. So what's the law here? Well, unfortunately, the law here is not clear. There are two views. The first view, I will tell you it's mine, and it's predominantly the American government's view, is that you may attack any, this is important, any member of an organized armed group, and you may attack civilians, in other words, civilians who are not part of an organized armed group, who directly participate in hostilities, and then the law goes on to say for such time as they participate. An example would be someone who implants an IED for money. He or she is not a member of a group, but for a certain amount of money, $300, they implant the IED, they get paid on a piecework basis. That's a civilian, but they're directly participating in hostilities. The second view, which is the International Committee of the Red Cross's view, is sort of the same, except with regard to the organized armed group, they add a caveat. And they say within that group, the only people that you can attack all the time are those individuals who have a continuous combat function. Talk about what that means in a second. So within this group, this is the United States Armed Force predominantly, all of you are targets all the time if your country's involved in an armed conflict. Doesn't matter what you do. Doesn't matter if you drive ships, fly jets, even if you're a lawyer. You are a target all the time. View 1 says, and that's also true for the groups we're fighting. View 2 says, no, for the groups we're fighting, it's those individuals who have this function. Everyone else is treated like a civilian, and you have to catch them in the act. I always get asked this question. There are groups, the classic example is Hamas, that are mixed. They have an armed wing, and they have a civilian wing that goes out and does relatively good things for the Palestinian population. If you have a group like that, everyone agrees that the non-armed wing part, they are not targets. You may not attack them until such time as they take up arms against you. Now, I mentioned the continuous combat function. I also used the term direct participation in hostilities. There is a current ongoing debate in international law over what these terms mean. We're not sure. We have some rough criteria. Clearly, everyone agrees that if we're talking shooters, if we're talking folks that do intelligence, at least at the tactical or operational level, if we're talking about anyone who plans an operation, anyone who approves an operation, everyone agrees those people are directly participating, and if they're in a group, they have a continuous combat function. There are some tougher cases that have come up. Logistics, what about people who are carrying weapons to the front? Components for IEDs, for example. Are they directly participating? What about people who are financing operations? Can we attack someone who provides general financing for a terrorist group? Or does it have to be financing for a particular operation? Again, the law's unclear here. And then a huge debate that came up unexpectedly as a result of a project I was involved with the ICRC, and also General Watkin, who's in the audience, who is a Stockton professor, had to do with assembling IEDs. The ICRC says if you're assembling an IED, that is not direct participation in hostilities. So if you know that there's some guy in a building assembling IEDs, that guy is not directly participating. You can attack the house because that's where the material is, but not the individual. And we all said that's, this is not computing. I don't get that part. It sure seems to me that if someone is assembling IEDs, then they are directly participating and they're a valid target. They are a target, as distinct from the IED material. Anyways, this shows you the scope of the disagreement over this particular issue. I also mentioned that you can attack them for such time as they participate. Again, there's a debate in international law. It involves targeted killings. There are two views, okay? The first view is, and it happens to be my view, it's primarily the Americans, most Americans embrace this view. It says, listen, you got a guy, he's a civilian, and he does stuff that rises to the level of direct participation against you on a recurring basis. That guy's in the fight. He's targetable through the whole period where he's doing this stuff. And the example would be the guy who does the IED. Everyone agrees civilian directly participating, okay, implanting the IED. In my mind, if that guy does it twice, then he's engaged in a continuous course of conduct, and you may target him at any time until such point as it's clear that he is no longer engaged in a recurring course of conduct. The International Committee of the Red Cross takes a different view. What they say is you may attack that individual while they're deploying to the operation, during the operation, when they're coming back, and that's it. This creates, in my mind, and the mind of many others, what's called a revolving door. So this tells me, be quiet. So I can target that guy when he's out. He leaves his wherever house. He's going out to an operation. Valid target, implants the IED, comes back, valid target, gets home, no longer a valid target. And you have to wait until that individual leaves again. Okay? To me, this doesn't make any sense. I mean, once the guy's done it, fool me once, shame on you. Fool me twice, shame on me. Once the guy is done twice, involved in a continuous course of conduct, and therefore the burden shifts from me to know what that guy's doing to him to demonstrate he's not doing it anymore. Last question is, how must you conduct the operations? And this should be relatively easy because this is, remember I said it's armed conflict, so standard law of armed conflict applies here. The first is the principle of proportionality, not the proportionality I talked about earlier, but the proportionality in the law of armed conflict. Rules very easily stated. You cannot engage in an operation if the expected collateral damage is excessive relative to the military advantage you anticipate. 2 points here. The law, the word in law is excessive, so you do not do body count comparisons. We're not doing a balancing. This is not a law of balancing. This is simply saying I've conducted an operation, and in light of what I reasonably expected to get out of that operation, this number of civilian casualties, that's reasonable. It's not excessive. Secondly, note the words anticipated and expected. What happened after the operation is not relevant. It's what was in the mind of the individual that planned, approved, and executed that mission. So long as that expectation of collateral damage and anticipation of military advantage was reasonable. There's no ex post facto assessment of the legality of these strikes. Second rule is precautions in attack. This is a requirement, a legal requirement, to do everything feasible to really keep down collateral damage. It's a legal requirement. This is not best practice. This is legal requirement. But understand that the law understands that everything that's possible doesn't make good sense. So there is a requirement to verify a target, but only to do everything that's feasible to verify a target in those circumstances. As you all know better than me, often there are other things you can do to verify the target, but in light of the ops tempo, in light of other objectives, it may not make good military sense. You don't have to do that, and the law acknowledges that. There's a requirement to select weapons, targets, tactics in order to minimize collateral damage, but again, only to the sense it makes good sense. There is a warning requirement if it's going to harm civilians. This requirement almost never applies because to the extent that you warn the civilians, hey, we're coming, then of course your target will go away. And the thing I want to emphasize here is, although there is this requirement, there is no requirement, this is acknowledged by the ICRC, there is no requirement to do things that don't make good common sense militarily. There's no requirement, for example, to accept undue risk in these operations. And then who can shoot? We hear a lot about this, and it's always the CIA. Okay? This is a non-issue. This is where everyone has gotten horribly, horribly confused. If you are in an international armed conflict, state on state, okay, then there is no law which says that military personnel must conduct an operation. What the law says is that only military personnel enjoy what is called belligerent immunity. What does that mean? That means if you're in the United States Armed Forces and you conduct an operation that is lawful under the law of war, you may not be prosecuted for that, not in international tribunals and not in any domestic tribunal. You enjoy immunity from prosecution for your lawful acts pursuant to the law of armed conflict. A member of the CIA, there's no prohibition on them participating, but a member of the CIA or any other civilian contractor who engages does not enjoy belligerent immunity. So if they kill someone and they happen to fall within the jurisdiction of the other state can try them for murder if they wish. That's the difference. In a non-international armed conflict, there's no prohibition at all on who may apply force, and this makes sense. Because in a non-international armed conflict, you may want the military to engage in operations, you may want police forces to engage in operations, you may want intelligence agencies, so the international community has set no rules. So the whole issue of civilians, contractors, intelligence agencies engaging in the use of force is absolutely a non-issue. It's a political issue, but it's a non-legal issue. And with that, I think I'm finished, and I guess we'll open it up to questions.
Well, I have a couple of questions. I have a couple of questions. That was very educational and informative. I've read so much of this, and I think I commend Mike for presenting a clear and concise view of what seems to me to be a very complicated area of law. Just on your last point, Mike, when I was quoting Human Rights Watch and certain intelligence and military experts were arguing, not as a legal matter, but as a policy matter, that it would be better to have the military carry out targeted killings because of the increased accountability and transparency procedures that are followed. But I'd love to ask you what to me are the hardest and most unique issues that are posed by Al-Awlaki and a couple other cases involving citizens, and in particular, the two factors that the ACLU zeroed in on in our lawsuit. Number one, this concept of being far away from a battlefield. And we're not, I mean, we were concerned, but this wasn't the focus of our litigation, that whether or not Yemen gave consent is a separate issue. Right. The question is it appropriate to target an individual there? And if there, then how would you distinguish, as I assume you would distinguish, but maybe not, targeting him if he came to the United States or went to Germany or some other country? And I think those who support this policy kind of have a gut reaction that there are certain countries where we would not want this power to be extended. So what are the geographical boundaries, if any? Secondly, I'll confess that strictly from a constitutional law point of view, I don't think there's a big significance between a citizen and a non-citizen, because the U.S. constitutional provisions that I read to you guarantee certain rights to persons and don't draw a distinction on the basis of citizenship. But the U.S. Supreme Court has given even more rights to citizens. Do you think there should be any different standards for the targeted killing of a citizen? And then I guess I'll ask you, to me, one of the most problematic issues about the war on terror, in addition to the potential lack of geographical boundaries, which I already touched on, the potential lack of temporal boundaries as well. And I'll have to say, even the most hawkish people that I've debated post 9/11, including John Yoo, has said that he's concerned about this concept of a war that will just go on forever and ever and ever and change what our legal standards are in perpetuity.
Before you answer that, Mike, could I pile on one other sub-question to the very first one? The nature of Al-Awlaki's participation.
You have the right to say no. I'll be your lawyer.
No, Al-Awlaki was a propagandist. He was a teacher. He was an inciter. But in no way was he directly involved in attacks on the United States, so far as I know. So is being a propagandist, is being an inciter, make him a combatant.
I'll just say the administration did claim that he played an operational role, so they seem to think that being a propagandist might not be enough.
Okay. This is hard because my boss and my boss's boss are in the front row, so let me try and do something intelligent here. Let's start with far away from the battlefield. This is a very interesting question. It's an ongoing debate, and in fact, the International Law Department will be conducting a closed workshop where we get a bunch of smart people into a room, lock the doors, and it's non-attribution to address this very issue. So it's certainly not settled. Let me tell you what my view is. I think that with regard to the law of international armed conflict, state on state, and that would, in the targeted killing, that would only apply to a terrorist group that is working on behalf of a state, which that is not usually the case. There, the law is crystal clear. You can conduct the operation in belligerent territory, international airspace, international waters, and to get across the border into neutral territory, the neutral has to be doing nothing. With regard to a non-international armed conflict, here we have a real debate. And it's not just going international, it's within a country. I have had some wonderful discussions with some friends at the ICRC on even within Afghanistan, for example. If you have active hostilities in one part of Afghanistan, does that mean you have a non-international armed conflict there, where you apply the law of armed conflict, but if there are no hostilities in the other part of the country, then you apply international human rights law, which would dramatically change your operations. I don't know the answer to the question. That's why my boss, Dean Rubel, has graciously given us a lot of money to conduct this. My personal view is the issue with regard to targeting is not location, it's status. In other words, you may target those individuals who are either combatants, members of an organized armed group, or they are civilians directly participating, wherever they may be. However, you must be sensitive to so it's lawful to target. However, you must be sensitive to the principle of sovereignty, because the fact that I can attack him because he's clearly a terrorist, I can attack him, doesn't mean I haven't violated the rights of the state where the operation occurs, and that's a different issue that involves a different analysis. But my answer is, pursuant to the law of war, the law of armed conflict, I think in both these cases, targetability is based on status or actions in the case of civilians, not on location, but more will follow. I instantly say the reason we're conducting this at the War College is because this is a tough question.
And can I just weigh in on that? Because I think the ACLU acknowledged that status point, and therefore it became very relevant to show that there was no justification for usurping Yemen's sovereignty. So we recited in our complaint and put in evidence through affidavits. I just want you all to know this, because we wouldn't have made this claim with respect to certain other territories, but we argued that Yemeni officials have publicly stated that their government security forces are taking measures to arrest him for possible charge and trial. Cabinet members in Yemen have also publicly requested that the United States provide the Yemeni government with any evidence against him to support arresting him and bringing him to trial. The Yemeni government has prosecuted other residents of Yemen for terrorism-related crimes, and the government is currently prosecuting at least one U.S. citizen who is alleged to be a member of a terrorist organization. Also, he in the past had been detained by the Yemeni government, was imprisoned there for 18 months. So we were making the case that, you know, that was a sovereignty that we didn't have authority or justification.
It's a very good question, very good point you're making, because remember what I talked about in terms of self-defense. In order to cross the self-defense threshold, you have to have necessity. You don't have necessity in the event that other measures are available.
Okay, Mike, you know what, I'm going to have to exercise the privileges of the chair, because we only have 10 minutes left, and I want to make absolutely certain we allow the students a little time to ask questions. So yes, please.